Hello, and welcome to yet another episode where we are looking at issues around the law that are pertinent and related to the contemporary uh, day-to-day events that we face in the world. As you know, there has been considerable areas in the world, in particular the area I'm focusing on, East Africa or the Horn of Africa, where there has been violent conflict, notably in Sudan and Congo, often uh, crossing a porous border into Uganda, where 41, reportedly at least 41 people were killed, including school children, when gunmen attacked the school. So that leads the question. We have had a tribunal in Rwanda, in Arusha, that covers Rwanda, based in Arusha, for many, many years following the genocide in Rwanda. We've had a tribunal in Sierra Leone. And so the question has to be is what role do these international law mechanisms, international institutions play as a panacea, as a prevention measure against conflict and resolution, in particular in East Africa, the Horn of Africa. So, just generally speaking, the international law provides a framework or a set of rules that govern the behavior of states and can help prevent, resolve, and disputes between countries. There are some ways in which international law can contribute to conflict resolution, in particular in East Africa. So, in principle, one is the peaceful settlement of disputes, where international law encourages states to resolve their conflicts peacefully through negotiation, mediation, and arbitration. The United Nations Charter, for example, promotes the peaceful settlement of disputes and provides mechanisms such as the International Court of Justice and the Permanent Court of Arbitration to assist in resolving disputes between states. Secondly, humanitarian law and protection of civilians. Under that law, international law, also known as the the laws of war, aims to limit the effects of armed conflict and protect civilians and other non-combatants. It prohibits actions such as indiscriminate attacks, the use of certain weapons, the mistreatment of prisoners. And by adhering to these laws, countries can mitigate the suffering caused by conflict and reduce the likelihood of escalation. The third ways in which international law should ideally resolve conflicts and prevent escalation of violence, political violence, is through diplomacy and treaty obligations. Now, international treaties and agreements provide a legal framework for resolving disputes, and in particular in East Africa, the countries are parties to various regional and international agreements, such as the African Union, Constitutive Act, the East African Community Treaty, and the United Nations Convention on the Law of the Sea, which are sort of a framework in which diplomacy and other obligations can be discussed and, if possible, through diplomacy, followed. Now, these treaties establish a mechanism for dialogue, cooperation, and dispute resolution among member states. The third way is through international mediation and peacekeeping. Now, international law supports mediation efforts and the deployment of peacekeeping missions to facilitate conflict resolution. For example, the African Union, for instance, has a Peace and Security Council that can mediate disputes and authorize, for instance, peacekeeping operations in East Africa. The United Nations plays a vital role in peacekeeping operations in the region and works in collaboration with regional organizations and governments to maintain peace and stability. Accountability and transnational justice is another way in which international law can play a role through promoting accountability for human rights abuses and violations of international humanitarian law. Now, mechanisms such as international criminal tribunals, like the International Criminal Court, have been established to prosecute individuals responsible for crimes, genocide, and crimes against humanity, which then hold perpetrators accountable to justice, reconciliation, and the prevention of future conflicts. Now, it's important to note that whilst international law provides a framework for conflict resolution, its effectiveness ultimately depends on the willingness of states to abide by its principles and comply with their obligation. Political will, regional cooperation, and the active engagement of East African governments, along with international actors, are crucial for the successful operation of international law in resolving conflicts in the region. And so that's really is a wrap up in a nutshell how international law could potentially be used to prevent and resolve conflicts. I need to stress that its effectiveness in fostering democracy um, depends on the political will of states and in the implementation of international legal obligation and engagement of regional and international actors. Ultimately, sustainable democratic development requires a comprehensive approach that combines legal frameworks, institutional capacity building, civic education, and genuine political commitment from governments in the Great Lakes region. No one can do it for them. And so hopefully that gives a nutshell of how international law can help resolve the conflict in Sudan. But in the end, it comes down to the parties on the ground in cooperation with the practical will and international partners. So there we shall leave it on this episode of The Diary of a Lawyer, and we shall speak again. Thanks for listening. Bye.